We're now on the record for case number 2023-2589-DM, Victoria Bavra versus Jesus de la Torre Bavra. It is Tuesday, July 9th, 2024 at 1:39 p.m. Attorney Schaefer for the plaintiff and Attorney Waldman for the defendant.
Good afternoon to everyone.
Good afternoon, Judge.
Court will note, as Mr. Moldovan has stated, his client is appearing on phone as he was not able to get on and zoom in. But he's appearing and hearing by phone. This matter is heard for trial on May 31st, 2024, and continued on June 27, 2004, at which time we concluded. Is there anything else, Mr. Schaefer, before the court grants its ruling?
I don't believe so, Your Honor.
Okay, Mr. Moldovan?
Nothing, Your Honor. Thank you.
Okay, thank you. Well, the court will first find that the testimony in this case does provide a statutory or satisfy the statutory basis for a granting of divorce, so the court will grant the divorce. The parties were married on July 7, 2017 and separated approximately January 1, 2023. So we have approximately a 5.5-year marriage. The parties have 3 children, Ava 8, Everly 5, and Eli 2. In this matter, the court always has and always looks at credibility of again, the parties in every case. In this case, as it relates, unlike in many cases I have, is the court did not find really any substantial contradictions between the testimony, and the court did find that both of the parties were credible in the testimony that they provided. The plaintiff had originally requested physical custody in her complaint. However, the court would note both attorneys acknowledged on closing that this case was appropriate for an award of joint legal and joint physical custody. Pursuant to MCL 722.26a, the court must advise the parties of joint custody, and the court shall consider the factors under the Child Custody Act as delineated under MCL 722.23 and determine if the parents will be able to cooperate and generally agree concerning important decisions affecting the welfare of the children. Before I go through and examine the best interest factors, the court must determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time, the children naturally look to the custodian in that environment for guidance, discipline, necessity of life, and parental comfort. During the time that the parties were together, the evidence has shown that they both participated in the raising of the children. There has been no evidence that would refute this. Pursuant to the case of Bofasil versus Bofasil at 332 Mish App 232, a 2020 case, the court recognized that parents can fulfill different needs and role in providing security, stability, and permanence. Recognizing this distinction, the court stated that although different, where each parent regularly and routinely is involved in the child's or the children's daily care, an established custodial environment may exist in both homes. Recently, in the case of Sabatine versus Sabatine, a Supreme Court case that was just handed down last month.
Your Honor, I'm sorry. Something happened to my sound.
You lost your sound?
I can't hear right now, Your Honor.
Okay, well, we weren't saying anything, but I guess I can keep talking until such time as you may find you can hear now.
I can hear. Sorry.
Did you hear the part when I was referencing the Bofasil case?
That was about right where it was right after that where it cut out. So.
Okay. I was going to say, in the recent case of Sabatine versus Sabatine, it was decided last month, the Supreme Court held that the court must look at the circumstances at the time that the court is making its decision to determine whether an established custodial environment exists. In this case, the parties separated, I said previously, on or about January 1, 2023. At that time, the parties agreed to parenting time with plaintiff Friday through Monday, and plaintiff testified that within a few weeks, the parenting time schedule changed to Friday at approximately 3:00 p.m. through Tuesday morning, when defendant would pick up the children and take them to school. Defendant claims that the present schedule started after the school year began and was supposed to be only temporary schedule. Notwithstanding what either of the parties thought, the current schedule has continued for either a year or 9 months, depending upon which rendition of the testimony is accurate. Both parties testified about their relationship with the children. They testified that they have a close, loving relationship and that they have both provided guidance to the children and that the relationship is permanent. Based upon all of the testimony, it is clear that an established custodial environment does exist in the home of both of the parties. As a result, and I believe that this is why at closing that both the attorneys confirm that this should continue. When an established custodial environment exists, the court cannot change custody unless the parties present clear and convincing evidence. The court should do so. The court will now examine the best interest of the child test. As delineated in this matter under MCL 722.23. The first factor the court has to look at is the love, affection, and other emotional ties existing between the parties involved and the children. Both of the parties testified that they love, have affection, and are bonded to the children. Plaintiff testified that her relationship with the children was strong. They are comfortable with her, and she is consistent. She is comfortable. So she testified she's comfortable with defendant's care of the children. Ekaterina Cole, the plaintiff's sister, testified that plaintiff and the children have a very close relationship, and William Inman testified that plaintiff and the children have a close relationship. Defendant testified how he hugs and kisses the children and they reciprocate to him, and that the children love to sleep with him and there is a tight bond between he and the children. I also consider all the other testimony, but that is just a highlight. And in this case, when I do so, I find that this factor weighs equally as to both parents. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education of raising the children in their particular religion or creed. It appears that both parties have provided the children with a loving, affectionate home and provided guidance and continue them in their education, although there is a dispute over the school, and I will address that later. Neither party addressed any religious upbringing in this case. So the court would not consider that as it relates to this factor. When I look at, again, the testimony presented and all the evidence, the court does believe that this factor weighs equally as to both parties. Next factor is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the laws of the state in place of medical care and other material needs. Both of the parties have demonstrated their ability to provide for the material needs of the children. Plaintiff has complained that defendant didn't acquire full-time employment to provide medical insurance. However, the court would note that the children were on Medicaid for a time before plaintiff acquired health insurance for them. The testimony also showed that both of the parties have provided for the medical needs while the children are in their respective care. They also have been able to and have provided for the material needs, clothing, food, all of those material needs while the children are with them. So the court will weigh this factor equal as to both parties. Next factor is the length of time that the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity. Court will note that the plaintiff testified she purchased a home in Battle Creek after separation. She testified that the parties did reside in the home that defendant is in for a few years before separation. She stated that the home was adequate at that time. She testified that the house only has one bedroom. However, defendant testified that the house has two bedrooms. He also testified he has planned to add 3 bedrooms and a bathroom now that he has had his plans approved for a new septic system. Plaintiff testified she desires to move to Marshall, where her family resides. William Inman testified that plaintiff's home is appropriate, and the court believes that both of the residents of the parties are stable and satisfactory. As a result, the court will weigh this factor equal as to both of the parties. Next factor is the permanency of the family unit of the existing or proposed custodial home or homes. In this case, neither of the parties testified that they were dating anyone seriously, although both have dated following the separation. As a result, the court will weigh this factor equally. Next factor is the moral fitness of the parties involved. Plaintiff testified she has no criminal record. Defendant testified that he had a DUI back in 2012 before he met plaintiff and had children. And defendant testified that he stopped drinking in 2015 and has not had anything to drink during the marriage. Court does not note or had heard any other testimony about the moral fitness of the parties. As a result, the court will find this factor weighs equally as to both parties. Next factor is the mental and physical health of the parties. There's been no testimony that either party has any mental or physical health issues, and as a result, the court will weigh that factor equally. Next factor is the homeschool and community record of the children. Court will note that Ava and Everly attend Gull Lake schools where they have attended their entire lives. Ava completed 3rd grade. Everly just completed kindergarten. The parties did testify that the children are doing well in school and that they have friends. It did appear that Ava did miss a significant number of days of school, and plaintiff proposes a move that would change the children's school. This would, of course, if she were to do that, would be a substantial change in the children's lives if they were to have to move school. As a result of her desire to change the school, the court will find that this factor does slightly favor defendant's father. Next factor is the reasonable preference of the children. In this case, the court did interview Ava and Everly. I did not interview Eli as he is too young. The court has found the girls to be pleasant, polite, and the court will consider their preference for purposes of the best interest. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and other parent in this matter. It does appear that the parties have attempted to accommodate each other's schedules. Each professed a willingness to continue to cooperate, and the defendant, however, did raise the issue the plaintiff did not provide him with any holiday parenting time in the last year except for Father's Day. The court does believe that the parties will be able to facilitate this in the future, and as a result, the court will weigh this factor equally. The next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. Each of the parties testified that there was no domestic violence during the marriage. As a result, the court will not consider this factor. The last factor is any other factors the court considers to be relevant in the child custody dispute. The court doesn't believe that based upon the testimony, there's been any other factors in this particular matter. The court notes that as the court considers the factors, the court does not weigh them like baseball box scores, and the appellate courts have held that the court can give greater weight to any of the factors and not consider factors that may not be relevant. When I weigh the factors, the court finds that there is not clear and convincing evidence sufficient to change the established custodial environment in this case, and the court will therefore grant the parties joint legal and joint physical custody. Court then has to look at under parenting time as provided for under MCL 722.27A. It is presumed pursuant to the statute that best interest of the child if they have a strong relationship with both parents. Under subsection I, the court has to evaluate the best interest factors that are in dispute. Court has to consider the following factors. Number one, special circumstances or needs of the children. The court does not believe that there's any substantial circumstances or needs that the court would need to consider in this case. Next is whether the child is less than one. The child is not. Eli is 2. And so the court will not consider that factor. Next factor, likelihood of abuse or neglect of the children during parenting time. There's been absolutely no testimony about any abuse of the children during parenting time, so the court will not consider that. Next factor, likelihood of abuse of a parent during the exercise of parenting time. Likewise, there's been no testimony about either party being abused, so the court will not give any weight to that. Next factor is inconvenience or burdensome impact of travel on the children. In this case, even though there's some distance, the children are still again, within a reasonable distance from each of the parents, and the court will find that the transportation is not burdensome in this particular matter. Next factor is whether a parent can reasonably be expected to exercise ordered parenting time. They have exercised all of their parenting time so far. The court believes that they would in the future, and therefore the court doesn't find any, I guess you'd say, exception in this particular matter. Next factor is whether parents frequently fail to exercise parenting time, which the testimony has shown that they have not. Next is threatened or actual detention of a child or children. There's been no testimony about any detention of the children. And the last is any other relevant factors. In this case, the plaintiff testified she wants the current schedule to continue. She does not want the children in daycare and believes that if the current schedule is not maintained, she will have to find another job. Her employer made accommodation for her by allowing her to have Monday off and to go in later on Tuesday to accommodate the time with the children. Defendant states that he has not had a holiday, as I stated in the last year, except Father's Day, nor has he had a weekend. The current schedule has been working well and accommodating the work schedule of both parties. As a result, the court does believe it is appropriate based upon the best interest factors as the court had previously examined, as well as the factors under MCL 722.27A parens 1, that the current schedule is working, and the court will continue the current schedule with the following exception. The parties will alternate holidays, with defendant having the next holiday, which would be Labor Day, and then alternating each holiday thereafter. Defendant will also receive the first weekend of each month, in which the entire weekend falls within the month from Friday, 6:00 p.m. through Sunday at 6:00 p.m. By example, in August, the first weekend starts on August 2nd, 2024, and the defendant shall receive that weekend. If the first weekend includes a holiday that is the plaintiff's holiday, whereby she would be entitled to an extended weekend, then the defendant would not get that first weekend, but would receive the second weekend of the month. To compensate plaintiff for this missed time, she would receive an overnight during the month from 6:00 p.m. to 6:00 p.m. on the next day, and it would be a day of her choice when she provides defendant 5 days notice of the day she wishes to receive. However, her makeup time she would not be entitled to receive a holiday or time on the defendant's weekend, but on the other days. Each party would receive 2 weeks of summer vacation, which they will take precedent over the other parenting time, however, not the holidays, upon providing 30 days notice to the other party. The 2 weeks will not, as I said, would not include a holiday, and the only one that would really be applicable was the 4th of July for the party that would receive that day. The next matter the court has to consider is school. In this case, as I stated, Ava and Everly currently attend Gull Lake Public Schools. Ava completed 3rd grade, Everly completed kindergarten. Neither child went to another school their entire lives. They're both doing well, have friends. Gull Lake is currently a school of choice, but after next school year, the children would be considered permanent students. Plaintiff did continue the children enrolled in Gull Lake schools for the next year. Plaintiff has proposed the children would go to Penfield or Marshall, which would be a school of choice as well. And the parties both testified that testified that the parties had agreed to have the children in Gull Lake schools when Ava first started back in 2020. Plaintiff testified that if the current parenting time schedule continues, it is fine to keep the children in Gull Lake. Plaintiff testified that when the parties discussed the children going to school, they chose Gull Lake because it was the best school around. Defendant testified that his and his family's connection with the Gull Lake schools. Court would inform the parties, as no one brought this up, but maybe it's just too early. Court would inform the parties that Gull Lake has a legacy scholarship program that'll pay for 2 years of college at KCC for students that attend kindergarten through 12th grade. After considering all the evidence, the court will order that the children would attend Gull Lake schools until they graduate from high school, or the parties would otherwise agree to change the school, which they would have to do in writing. Next, the court will address the issue of child support. Plaintiff is employed at Gallagher Uniform. She testified in 2023. She made between $53,000 and $56,000, and the court will take $55,000 as her income for calculation of support. She testified she has an insurance premium of $345 per month for her and the 3 children. When the court looks at this individually, that is a cost per child of $86.25 times the 3 children will result in a $258.75 deduction from her income for purposes of calculating child support. The defendant's job is flipping homes. He testified his income in 2023 was $34,000, but he anticipated making between $45,000 and $50,000 in 2024. He did testify that he had just in the past month had sold a house and flipped it. So what the court will do is the court will use $48,000 for his income for purposes of calculating support. Parties had also raised the issue of tax exemption for the children. Plaintiff took the deduction for all children in 2023. The defendant proposed that the parties would each take the deduction for one child and alternate on the third child. This appears to be fair and reasonable to the court. And so for the tax year 2024, defendant will receive the tax deduction for two children and plaintiff will receive the deduction for one child. And then thereafter, they will each alternate the deduction for the one child. Once a child would drop off, as it would be, because Ava would be the oldest. When Ava drops off, then the parties would each claim one child after the year that they were able to claim the two. And then when both children are off, when Ava and Everly off, then they would alternate years for Eli. With that, I believe that the court has addressed all the issues the court had to decide. Mr. Schaefer, is there anything you believe that the court had missed or failed to address before we conclude?
No, I believe you have covered it.
Okay, Mr. Moldovan, likewise, is there anything you believe I've missed or failed to address before we close the record?
The one thing I may have missed it. Did you say it a child support effective date, Your Honor, or was that upon entry of judgment?
The court will, I did not address the effective date. The court will make the effective date, the last date of trial being June 27, 2024. Thank you for addressing that, Mr. Moldovan. Anything else?
Nothing further, Your Honor.
Okay, thank you. I'll ask that Mr. Schaefer would prepare that as he represents the plaintiff. And just Mr. Moldovan, for your information on this is all on YouTube. We keep these up for a matter of 30 days so that the attorneys can go back over, because I know we address a lot of things and you may want to, in preparing the judgment, go back and clarify some points. So it'll be held up for 30 days and then they'll be taken down.
All right. Thank you, Your Honor.
Okay. Thank you all. You're free to go. Have a wonderful day and I wish you all the best.